What if I told you that fair representation at the ballot box is still up for debate in 2025? In Louisiana, where black votes make up a third of the population, lawmakers said that black voters being represented in only 1 out of 6 congressional districts was enough. And when a federal court tried to fix it, some white voters said, hold up, that's racial discrimination against us. Maybe I'm tripping, but if 1/3 of Louisiana's population is black, shouldn't 1/3 of its congressional districts reflect that? The next case on the docket this week is Louisiana v. Caius, the Supreme Court case that could reshape how America protects voting rights. Or fails to. I'm Legally Hype, your legal plug, and this week on the docket, we're talking representation, redistricting, and whether equal protection really means equal. Black voters in Louisiana have never been fairly represented, not at the state level nor federally. And now, a group of white voters are suing the state, claiming that Louisiana's updated congressional map gives black voters too much power. Yeah, you heard that right. So now, let's be clear. The Supreme Court's decision in this case could determine whether black voters anywhere have a real shot at fair political representation, or whether we just keep pretending inequality is neutrality. Here's the background of the case. In 2022, Louisiana's state legislator drew a congressional map with just 1 majority black district out of 6, despite the fact that a third of the state's population is black. That math ain't mathing. So a group of black voters sued under Section 2 of the Voting Rights Act, which prohibits voting practices that discriminate based on race. The federal district court agreed with the plaintiffs and told Louisiana, go on and run that map back. Yeah, go ahead and redraw it. Lawmakers did redraw the map to include 2 majority black districts. And that seems fair, right? Nope, not to some folks. A group of voters filed their own lawsuit claiming that adding a second black district amounted to racial gerrymandering and violated the Equal Protection Clause of the Constitution. Racial gerrymandering is when voting lines are drawn to intentionally dilute a racial group's voting power. Now, ironically, that's exactly what Section 2 of the Voting Rights Act was meant to stop. See, the Voting Rights Act was passed in 1965 at a time when black voters were routinely pushed out of the political process. But here's the issue that the Supreme Court is up against. On the one hand, the Voting Rights Act says that lawmakers must consider race to ensure that black voters aren't excluded from political representation. But on the other hand, the Equal Protection Clause of the Constitution says that lawmakers can't let race be the predominant factor in redistricting unless there's a compelling reason. That's the tightrope the court is walking. And by the way, this fight didn't come out of nowhere. Since the 2020 election, lawmakers across the country have introduced over 400 restrictive voting bills. And to be clear, many of those efforts are about preserving political power, not serving the people. In fact, Louisiana legislators admitted that they drew the congressional map the way they did to protect Republican leaders like House Speaker Mike Johnson and Julia Letlow, who sits on the Appropriations Committee, even if it meant diluting black voting power. Now, the Louisiana state legislature is in between a rock and a hard place at this point because on the one hand, they're satisfied with how the map is drawn in its current state. There are 2 majority black voting districts out of the 6, even though the districts are carved out smack down in the middle of the state, and Republicans get to keep their political power. But how do we even get here? The problem with racial discrimination in voting practices should have been resolved a long time ago, right? Yeah. We got to this point largely because of the 2013 Supreme Court case Shelby v. Holder, which gutted Section 5 of the Voting Rights Act, the part that required states with a history of discrimination to get federal approval before changing voting laws. Without that protection, states like Louisiana have been free to draw maps that sidestep fair representation, and now we're seeing the consequences. So then what happens next? Well, this case made it all the way to the US Supreme Court, and when it got there, they said, you know what, we're not ready. We're not ready to decide on this. No, seriously. The court postponed ruling on the case and asked for a second round of oral arguments next term. So now the only justice who disagreed, of course, was Clarence Thomas. He wrote a 6-page dissent arguing that there's no reason to delay ruling on this case and that the court must decide cases like this promptly. In fact, he firmly stated that these types of cases are the very types of cases the Supreme Court should be deciding, citing what he believes to be a conflict between Section 2 of the Voting Rights Act and the Constitution. And Thomas is clear that if there is a conflict between the two, well then he is likely to side with the Constitution, meaning the voters who filed this lawsuit could win. But we'll just have to wait until next term to find out how this will go. So now here's the big question. If 1/3 of Louisiana is black, Is it really discrimination to make 1/3 of its districts majority Black? Or are we watching a system fight tooth and nail to preserve power no matter who gets left behind? Drop your thoughts in the comments. Should Louisiana's redistricting plan stand? Or is this another example of progress being painted as prejudice? Have the day you deserve.